changing the course of your financial future. Hi, it's Martin Conway here today, and I'd like to speak about conversions. And I'm not talking about a religious experience. What I'm speaking of is the conversion of one bankruptcy chapter to another. So, say from a chapter 7 to a chapter 13, or a chapter 13 to a chapter 7. So, this is a very handy tool in our toolkit. The U.S. Supreme Court, in a case named Vigeland, says you can specifically, as provided for in the Bankruptcy Code, convert at any time to any chapter, so long as you're qualified in the chapter to which you're converting. So let's unpack this. It's a very handy tool. So let's start out with a chapter 7. Why would you convert your chapter 7 to chapter 13? Well, it happens once or twice a year or every other year that a chapter 7 trustee wants to sell your real estate. Now, obviously, you don't want to sell your house to the chapter 7 trustee. We normally wouldn't file your bankruptcy if we thought your house would be sold. What happens in these particular instances is there's a dispute over the value of the house, or the trustee is just being obstinate. In that case, you could convert your case to chapter 13 and pay the chapter 13 bankruptcy trustee what the chapter 7 trustee, what the creditors would have received upon the sale of your house. And so you're paying actually the chapter 13 trustee a reduced amount of money, because again, it's what the creditors would have received upon the sale of your house, not the proceeds of the sale of your house. Different mathematically, it's a different number. But that's very common, and you have the absolute right to do that. Also, we convert chapter 13. Say if you were in a chapter 13 because you were an above the mean filer, meaning your income was too high to qualify for a chapter 7. Why might we convert your case? Well, what happened if you were in an automobile accident, you became disabled, or you lost your job, or more positively, you had a baby, you had a family member added to your household. If there's a material change in financial circumstances and you no longer can afford your chapter 13 plan, then you can convert to a chapter 7. Do that all the time. Another frequent usage of the conversion is, say you were being garnished when you filed your chapter 13. Now, as you know, or many of you know, in garnishments I frequently will demand less money from you up front than in other situations. So you're being garnished. You don't want to default on your rent, your car, or your other household obligations. So you file your chapter 13 plan to stop your garnishment. By the way, that takes about 10 days to stop the garnishment once the case is filed. So again, the law says you could freely convert at any time. Obviously, you would need to pay us our fees for the conversion. I do think that, sometimes we can convert right away, but other times we may need to be in the plan, for 6 to 10 months. The creditors really are not going to receive anything. As soon as we are paid, we would convert your case. But I do have this concern, and the concern is I don't want to abuse that too much, because eventually the Chapter 13 trustees are going to get angry with me because they feel like they're being disrespected. Thomas Gorman in Alexandria is particularly sensitive to those kinds of feelings, and we don't want the trustees angry with us. And I think if we abuse it for everybody, they are going to get a little bit miffed, because they're there trying to get those plans to work, and our intent is really not to stick around. So we don't want to make that. We don't want to put it in their face. It may be true, but we don't want to rub their noses in it. So there are about 3 or 4 issues that I think you should be aware of when it comes to conversions. First of all, if you're above the mean filer and you still have some household income, you can't convert. Simple as that, because the U.S. Trustee's Office won't let you convert. Secondly, if you are not qualified for a Chapter 7 when you filed your Chapter 13, because you had filed a Chapter 7 less than 8 years ago when you filed your 13, you're still ineligible because eligibility is determined when you filed your Chapter 13, not later. And that just means you have to refile the case all over again. I don't make the rules. It's kind of like Simon says, but Congress makes the rules. The third issue is we need to be sensitive if you have a house and it's appreciated in value. In other words, what changes have occurred in your bankruptcy filing since you originally filed your Chapter 13? Sometimes clients, real estate has gone up way in value, and they can't convert, or they end up, unfortunately, what's called reconverting, which is you go from a 13 to 7 and back to 13. Does happen. That's even rarer, but it does happen because you can get a dispute with the Chapter 7 trustee over the value of the property. Having said all of that, I think the conversion is a very good tool in our toolkit. And if I'm not the king of conversions, I'm certainly a prince of conversions. I think we convert more than anyone I know. And it's just a handy way to get the relief that you're seeking. So pass it on. And those are the rules of the road. And let's get going on our journey. Thank you. Bye-bye.